Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs' internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinar brought to you by the Southeast Asia IP SME Helpdesk project. Today's webinar will be about IP updates in Indonesia and the role of customs. We are very pleased to have this special edition webinar on Indonesia because the truth is that it's been a long time that the Helpdesk did not talk about Indonesia, which is a very important country of our project. My name is Nora. I'm the project manager of the Southeast Asia IP SME Helpdesk project, and I will be today's webinar moderator. Before diving straight into the session, just a quick overview about the housekeeping rules. So first of all, today's webinar is recorded, so we will be pleased to share with you later on the presentation and the recording. If you have not been able to join or you want to cross-check any information, you will be muted during the webinar. However, we look forward to have an interactive Q&A at the end of the session. So please don't forget that we have a Q&A box on the Zoom platform, so you can type in any questions that you may have. And we suggest you to choose the gallery view so you can see the slides and the speakers. I would like to welcome our speakers for this webinar. So we have with us Andrew Diamond, external expert of the project and foreign IP consultant at Januar, Jahja and Partners based in Indonesia. And Eddy the Cuyper, he is the customs counsellor at the Embassy of Belgium in Jakarta, also responsible for other Southeast Asian countries. We will let you know about this later on. So just a quick overview on the agenda. So I will give you a short overview about our project, and then we will talk about updates on IP situation in Indonesia. This will be done by Andrew. After Eddy will take over and discuss further the role of customs, especially on IPR and in general in Indonesia. And then at the end, we would like to discuss with all of you. So once again, we very much look forward to have your questions. Regarding the services, I hope you already saw our video, so I would be very short here. The Helpdesk is an initiative of the European Commission. All services that we offer are free of charge for EU SMEs, and we provide IP advice to European companies to help them to enforce and protect their intellectual property rights in relation to the 10 ASEAN countries. If you come to our website, you can check our events calendar with all upcoming trainings. You can sign up to our newsletter to receive more information about IP in general and all activities that we are organizing, or download our guides and fact sheets, which are available in the Helpdesk library. And with, yes, and here is the game time. Sorry, we still have this part. So we would like to ask 2 IP-related questions to our kind audience. So the first question will be, IP Office of Indonesia automatically and systematically verifies the identity of an applicant for each new trademark application to prevent bad face registration cases. There is therefore no risk and no rush to protect my trademark in Indonesia. Is this true or false? Please select the correct answer. If you are not correct, don't worry, there is no punishment. The second question is, an invention patent grants an exclusive monopoly during a fixed period of time, several months before the expiry date of the patent. I can easily extend the duration of protection by filing a renewal request before the IP Office of Indonesia. True or false? We'll give you a few seconds. You can make up your mind, and then this webinar will answer to your questions. So don't worry, you will not stay without the correct answer. But first, we would like to hear from you, and we will also share the result with our experts so they can also have an understanding about how our audience thinks about this question now. Okay, so I think, I hope you had time to select the answer, so we can share the result now. So 77% thinks it's false, the first question. And for the second question, it's more interesting, the composition of the results for the second question. I like it. Okay, for the moment, we don't share with you the correct answer. And with that, I would like to give the floor to Andrew. Thank you.
Thank you for having me. My name is Andrew Diamond. I'm sharing my screen right now. I'm here to talk about the IP updates in Indonesia and the role specifically of small, medium enterprises and the IP office.
So, yeah, okay, perfect. It's on full screen now. Thank you, Andrew.
Yep.
All good. Yeah.
Slight delay there, but we're all set now. Just brief background on me. I'm an American attorney. I've been based in Jakarta for 10 years. And so I'm very happy to be here to be able to share some of the things that I've learned over my decade in Jakarta. Just a brief rundown on what I'll be talking about. You know, COVID obviously had an impact in a lot of different ways on Indonesia as well as every country around the world. So we'll briefly touch upon that with specific respect to how it affected the IP scene here. And then we'll briefly touch on the 4 core IP rights in Indonesia, being trademarks, patents, industrial design, and copyright. And then I'll briefly touch upon litigation disputes and then finish with talking about domains and social media before offering concluding remarks. We have a quick poll question though. I want to start off, and the question is, have you ever applied to register an IP right before in Indonesia?
Yes, thank you, Andrew. So the question should pop up. You should see the pop-up on your screen now to be able to vote. Option A is yes, trademark. Option B, yes, patent. Option C, yes, industrial design. D, yes, copyright. E, no, never. that could be very interesting for us to know where you stand in terms of registering any IP right in Indonesia. So, okay, maybe we can wait a few more seconds and then we share the results so Andrew can continue with his presentation. So let's see the result. Okay.
Interesting.
Thank you. Yeah, thank you, Andrew.
Very interesting. Okay, great. So obviously from the poll results, the vast majority of attendees for this webinar have not previously applied for an IP right in Indonesia. So I do think that is quite interesting. Just a brief rundown on Indonesia. Indonesia could be very easily described as large, young, and dense. It has the 4th largest population in the world, approximately 275 million people. It has a very young population on average with a median age of 30, and it's very dense. And so, you have almost 60% of that 275 million people living on the island of Java, which is where Jakarta is located, and a lot of the other largest cities in Indonesia, such as Bandung, Bogor, Surabaya, Semarang, Yogyakarta. And so it is very, even though it's spread out across, 17,000 islands, most of the population is on one island, being Java. Obviously, the pandemic affected every country around the world. Just from an economic perspective, Indonesia, it contracted by 2.1%, which I would say, relatively speaking, is quite good. It was a lot worse in a lot of other countries. It rebounded slightly in 2021 to grow at 3.7%, and has been estimated to grow 5% and 5.2% in 2022 and 2023. Those estimates are provided by the Asian Development Bank. Historically speaking, and even up to now, economic growth in Indonesia has been primarily driven by domestic consumption and commodity trading. We have very high commodity prices right now, so that's obviously helping Indonesia's foreign reserves, but inflation is posing a risk, as it is in a lot of other countries. Currently, it's around 3.5%, which is not as bad as other countries like America, but it is something definitely to keep an eye on. From a COVID perspective, COVID came here early. It's still around, obviously. The official tally is that there have been approximately 6 million cases to date, with 157,000 deaths, but the real totals are probably much, much higher. Currently, cases are quite low across the whole country. I believe that there's only one. They have a kind of a tiered system in Indonesia currently, and I believe that right now there's only one area that's in West Papua, in the far eastern part of the country, that has kind of a tier above the lowest. Everywhere else in the country is the lowest level. So that means that there's practically no restrictions other than mask requirements. So it feels almost normal, especially in Jakarta. Looking at kind of the IP scene, Indonesia does have a full set of laws and regulations, but kind of the issue is that there can be gaps, there can be delays, from a time perspective of years for the implementing regulations to come out. And, the regulations are not always written precisely. There's a lot of vague language that's coming in, being issued in Bahasa Indonesia, and then with official translations. So there's a number of issues that come up, especially since Indonesia is a civil law jurisdiction, where the written regulations and the statutes are of the utmost importance. So when we have gaps, or when we have language that's not clear, that creates a lot of problems to kind of guide people as to how they should be proceeding or conducting their business. The U.S. Trade Representative issues a report, a global report. It's called the 301 report. They issue it every year, focusing on intellectual property and access to markets. And in 2022, Indonesia remained on the priority watch list, which is not a good thing. There were concerns raised in the report with the ongoing problems of piracy and counterfeit goods, among other concerns. But the report does note that there have been positive developments made, including cooperation efforts between the Ministry of Communication Information and the Indonesian IP office. And so they're stepping up enforcement efforts, they're creating task forces, but it's going to, it's going to be a process that will take years, not months, to really see if there's a concerted effort to dent these problems of piracy and counterfeit. From the Indonesian IP office, they have an online filing system for all IP applications. There's no more manual filing. And so this was actually quite good. And I give the Indonesian IP office a lot of credit for when the pandemic hit and everyone went online. We were still able to file applications. Agents from all over Indonesia were still able to do this electronically. Their IT systems have held up quite well. They've added new functionality. And as part of that, original documents are not required because there is no manual filing system anymore. And so electronic signatures are accepted. Electronic signatures, I would clarify, as long as they look like a wet signature, even if they've been digitally created, that would be accepted. But if we're talking about like a /s/ and then a typed name, I would not say that that would be accepted. So as long as it looks like a wet signature, even if it's digitally created, it would be accepted for signing power of attorney to an agent, for signing a statement of entitlement or other required documents that would be needed to prepare your trademark application or your patent application, design application, and so on. These documents do not need to be legalized, which is great, meaning it does not need to go up to the Indonesian consulate or embassy in your country. That's not required. Notarization is not required except for certain things. So if you're going to litigate, right, in the court of law, it needs to be legalized. But that's sort of a special circumstance. Day-to-day filing of applications at the trademark office or the patent office does not require notarization or legalization at all. But if you're going to do an assignment, which is a transfer of rights, if you have acquired a brand from someone, or you're acquiring rights to some IP right, or you're selling it, that document, which is embodying that transfer of rights, must be notarized. And then it can be scanned and emailed to your agent in Indonesia for recordation to update the IP office database to record the new owner. So it's kind of interesting. I mean, because the Indonesian IP office already had their IT system set up and we could continue doing electronic filings, you can see, for example, with trademarks, that the total number of trademark applications filed in 2020, the first year of the pandemic, actually went up. And now in 2021, the second year of the pandemic, it's jumped considerably by 10%. And a lot of that has been driven, I don't have official statistics, but a lot of that has been driven by an increase in local filings, meaning an increase in filings by Indonesian individuals, Indonesian companies, organizations. And so that's quite interesting. And it's different from other Asian jurisdictions, such as Singapore or even Vietnam, where a large percentage of the applications in those jurisdictions are being filed from quote unquote foreign entities. That means entities outside of the country. In Indonesia, it's the opposite. Patents, you can see, are pretty much stable from 2019 until right now, looks pretty stable. Designs as well have rebounded. Copyright's kind of weird. It had this incredibly high number in 2019, dropped considerably in 2020, and has stayed about the same level for 2021. So copyright's different. We'll talk about it later, but that's something to kind of keep an eye on to see if that recovers. Interestingly enough, the courts in Indonesia, especially in Jakarta, have stayed open the entire time. They were never, there's no work from home, there's no virtual court. They've stayed open, they've been active. I know of a lot of high profile cases that have been litigated during this time of the pandemic. They are being shut sometimes if there's outbreaks, especially if the judges of a case get it or the clerks. That's the only time they're shut, and otherwise these courts are open and they're open for business, and parties can litigate, but it's in person for the most part. They're not doing virtual court. So one of the big impacts of the pandemic on Indonesia has been sort of the acceleration of the movement towards e-commerce and doing so many of your daily transactions and chores online. It was already, the groundwork had already been laid especially in the large cities, in Jakarta, in Bali as well, for this, with a lot of the ride-hailing apps here, really kind of revolutionizing day-to-day business and life here. But there have been a number of very large e-commerce platforms that have emerged in the last few years in Indonesia. These are some of the biggest ones: Tokopedia, Bukalapak, Shopee, Lazada. And right now it's estimated there's 158 million e-commerce users in Indonesia. That number is expected to grow. As you saw earlier, it's a relatively young population. They love technology. They're very much online. And so the size of the digital economy in Indonesia is expected to continue to increase. So for example, it was estimated to be worth 48 billion in 2020. And then by 2021, it was already worth, estimated, 70 billion. So it almost doubled in 1 year during a pandemic. And I think all the estimates continue to indicate that it's going to only increase, going forward. From an IP perspective, it really varies from, place to place and from platform to platform in terms of how easy it is to file and make IP complaints and to get takedowns. All of them require the IP owner, meaning you, the business owner, the owner of your own IP, to actively monitor and proactively file complaints. It can be a little bit cumbersome if you have a lot of counterfeit goods out there and a lot of different users, and you have to compile all the links. But the more detailed you are, the more success you will have. And so it's really important to be proactive. That the platforms, for the most part, will not do it for you. And when you are filing your request to deactivate links or users are more difficult, but to deactivate certain links, you need to provide proof of your IP registration. Looking at trademarks, it is generally recognized as the strongest IP right. Indonesia uses a first-to-file system, which means that the party that has the earlier filing date has the superior rights. It's different from a lot of other countries that use a common law system, such as the United States, which provides certain rights to parties that use their trademarks first. That is not the case in Indonesia. Using your trademark in Indonesia without registration is very risky, and it's quite dangerous. There's no regional filing system for ASEAN, so you cannot just file one application to cover all the ASEAN countries. Instead, there's two options. There's the national application, which would be you instructing a local agent to file your trademark application with the Indonesian IP office and engaging with that local agent on an ongoing basis for the registration of your trademark. The other option would be filing an international application via the Madrid Protocol, where you can select the number of countries that you wish to designate and enter into that jurisdiction. I would say that they both have their advantages and disadvantages. The main advantage of the Madrid Protocol is that it is cheaper, theoretically, because you're only paying the official fees for each of the countries that you are selecting. Going back to the original, the first question, full question that we had, talking about bad faith filings. Unfortunately, Indonesia does have a history of bad faith filings. That's trademark squatting, which means essentially someone applying to register and then successfully registering your trademark before. It is continuing to this day. It is an ongoing problem. It is a serious problem. And so it's very, very, very important to file your trademark application as soon as you know that Indonesia is a jurisdiction that you may go into. Prospectively, if you're looking ahead in 5 years, will you be in Indonesia? File your trademark application. Do not wait until you're already big in Singapore or you're already in Malaysia or China. People are monitoring those markets. They travel to those countries and they see new brands. They come back to Indonesia and they file them, and they will ask you for a lot of money from them. So it's very important to file your trademark as early as possible in Indonesia to try and avoid this problem. This problem exists even with local distributors or your local partners. So people that you're doing business with, that you're trying to trust. It is possible, and it happens a lot, where while you're negotiating with them or after you negotiate with them, they will say, or maybe not even tell you, but they will register your trademark in their own name. And if they do that before you do, it is very complicated, expensive, time-consuming to get it. So in order to avoid that problem, you can file as soon as possible, as I mentioned, and you can conduct like research, background checks, due diligence on your local partner about whether they have filed your application already or your trademark, whether they've been involved in lawsuits at the courts, what kind of lawsuits, things like that. It's important to check who your partner is and what their background is. Another possibility is in your agreement with your local partner, you can have an IP clause, or you can have a few IP clauses. And what that means is it's basically language from your local partner acknowledging that you are the owner of this trademark and that you own all the rights. And whether they're using your trademark or not, that doesn't mean that they acquire any rights to your mark. Another IP clause that you could have in there is that the local partner pledges to not file a trademark application for any word or logos that are similar or substantially similar or identical to your own, and that they will not have any third party do it for them. So these are clauses that are quite important to have in place with your local. So the registration process takes about 12 to 18 months from filing until grant, assuming no issues. So because it's taking about a year, year and a half, it's important to find out before you file if someone else has already filed your trademark or has something very similar to your trademark. And conducting a search beforehand is a really good way. You engage a local agent to conduct a search and provide you with a report that includes the prior marks that are listed in the Indonesian trademark database. And they will give you their opinion as to whether they think that your trademark has a good chance of success to be registered. This is really important information because if someone already registered your mark, you don't want to file an application and wait a year and a half to find out that your application was always going to be rejected. Instead, you need to engage with that person immediately, or you need to come up with another plan. Once your trademark has been registered, so you've gone through the year and a half process, you have your certificate, everything went well, you have a 3-year grace period from the registration date in order to use your trademark in Indonesia. If you do not use it during the 3-year period, your trademark becomes technically vulnerable to non-use cancellation. Basically, Indonesia wants you to be using your trademark in Indonesia. If you're not, it creates a risk. And that means that someone can go to court and they can submit a report and say that you're not using your mark, and they can try and get it canceled. So that's something to keep in mind. But there's no proof of use or declaration of use that needs to be filed as part of your registration. There's just a renewal period every 10 years, and this can be renewed indefinitely every 10 years. But as part of that renewal, you have to sign a statement of use, which says your mark is being used in Indonesia. So that's something to think about. Looking at patents, there's 3 ways to file a patent in Indonesia. So patents are protecting inventions, right? Trademarks are protecting, you can think about it as brands. Patents are looking at inventions. And there's 3 ways to protect your invention in Indonesia. One is through the PCT system. This is the most common. It's an international system with over 100 members, and you're just checking boxes and you're engaging with your patent agent as to what countries you want to do, and you're getting advice from them. Another one is via the Paris Convention, which is another international treaty where you can file directly in Indonesia. And the third one, the last one, is where you file just immediately in Indonesia without reference to a patent application in any other country. Of these 3, I would say the PCT system or the Paris Convention is definitely the most preferable, because the way that patent examination works in Indonesia is that the examiners here are going to want to see the examination report from another country. They're going to want to know what someone else said about your invention as to whether or not it should be granted a patent. And so I've listed 6 key jurisdictions here. I've bolded them. You can see the US, EU, Japan, South Korea, China, and Australia. Those are really very persuasive jurisdictions. So if you have a grant of your patent, or you have a positive examination report from one of those jurisdictions, that is very, very useful. That's great information, and that can absolutely be used for your patent application in Indonesia, and it can really smooth the process. Two other things quickly to note. One is that for every patent that you have to list very specifically what you're claiming, and that determines your scope of protection for your patent. If you have more than 10 claims, and some patents have 100, some have 50, it really depends on how it's been drafted. Every claim above 10, you pay additional fees. And it goes again with translation. Translation into Indonesian is required, as is English. So if your patent is not being prepared in English, it will also need to be translated into English as part of the submission to the Indonesian patent office. And so it's really important because the Indonesian translation in particular will determine your scope of protection. So if your Indonesian translation is not good, then you're going to have protection for a poorly translated patent, which is not what Indonesian. There's a couple of very specific things that sometimes come up. One is called the Patent Prosecution Highway. It's an agreement between certain patent offices to kind of facilitate examination and grant of patents. Right now, Indonesia only has one such agreement, and that's with the Japan Patent Office. There's another one called ASPEC, which relates to the Southeast Asian patent regime, and where you can use a grant decision from Singapore or Malaysia for, again, smoothing the examination process in Indonesia. My opinion, it's not worth it. There's a lot of official fees that need to be paid, and instead, it's much more beneficial to have a positive grant decision from one of those 6 jurisdictions that I identified above. So currently, it's taking 3 years from filing to grant in Indonesia. That's a big improvement from 4 or 5 years ago, where it's taking 6-7 years. So they've really streamlined the process, made really good progress on that. So once you get your patent granted, this is not included, but it's just some additional information. It's kind of similar to trademarks. You have 3 years to use your patent, to implement it. And according to the current law, implementing means producing, importing, or licensing. So if you are not doing one of those 3 things within 3 years from when your patent has been granted in Indonesia, it's technically vulnerable to someone applying to the Indonesian government and obtaining a compulsory license. Basically means they can use your patent, even if you don't want them to. They have to pay you, but it's going to be less than the commercial terms you would negotiate normally. Industrial designs, this is to protect aesthetic creations. The classic examples are, unique furniture, a really unique bottle, product packaging, things like that. It must be novel, which means that if you are already using it in trade, if you've already started selling it in the market, it is not going to be accepted as an industrial design right in Indonesia. Instead, in that case, you can consider filing it as a 3D trademark possibly, but even better is if you are filing it before it's been disclosed to the world, or it's within your 6-month priority period from your initial application, perhaps in the EU. It's taking about 2 to 3 years, assuming no issues from filing to when an industrial design will be granted. And then you have 10 years of protection, but it cannot be extended. A shorter period of protection than patents. Patents are 20 years. It's not extendable, but and similarly for industrial designs, it's 10 years, but it cannot be extended either. Industrial design can be really difficult because it's designed to protect aesthetic creations. If that aesthetic has been changed kind of in any real way, it goes outside the scope of your industrial design protection. So small changes in the configuration can make it really difficult to enforce that civilly in the courts or criminally by filing a police report. Copyright is generally recognized as the weakest IP right in Indonesia. Historically, there's a lot of problems protecting the written word in the form of books or music or movies. And this was kind of mentioned in the U.S. Trade Representative report, the 301 report I was mentioning earlier. It's automatic protection. That's the international copyright scheme. If you produce something in written form it is yours. You own it. You own the copyright on it. But in order to have any rights in Indonesia, you need to record that with the Indonesian IP office first. That is a requisite. No one will do anything here without an actual, certificate of recordation of your copyright. The process is very quick. It takes about 2 weeks. So if you have something that is eligible to be copyrighted in Indonesia, the process can be, fast, and you can have your certificate quite quickly. Moving quickly to litigation and disputes. I guess the nicest way to say it is that litigation can be unpredictable in Indonesia. There are cases that have decisions that you think should go one way and go another, and vice versa. But there are also a lot of decisions where you can look at it objectively and say that's the right result. And so I do think that it can be a viable option in certain circumstances, but it really depends on the facts of that specific situation, who the parties are, what your budgets are. But people often, once you have an IP right, people often are looking to enforce it against people that are infringing upon that right, and want to know about preliminary injunctions. Can you go to a court and get someone to stop doing this infringing activity? And they're theoretically available because there's written regulations and laws that provide for them, but in practice, it's not available. It requires you to put up a bond with the court, and if you lose at any stage of the proceeding, you forfeit the bond. And the bond is supposed to be equal to the value of the goods that you are claiming being infringed. So if you think that there's $1 million worth of damages being committed against you by these infringing goods, you would need to put up $1 million bond. And you can see why people wouldn't necessarily want to do that. The other part is, even after you obtain your preliminary injunction, you still have to go through an entire infringement trial. So what a lot of people will do is they'll skip an preliminary injunction and just go straight to file an infringement claim. That way they don't have to put up a bond, and they can just jump right to the infringement trial and a full hearing. If you litigate, if you file a lawsuit against someone in Indonesia, that is serious business. It's not a great way to get negotiating power. Most people won't negotiate with you after you've filed a lawsuit. So if you do want private resolution, you need to do that before you litigate. And so you try to contact them, send letters, contact their agents or attorneys, and you do it separately before litigation is commenced. Arbitration is not really popular. There's no real history of arbitration here. There is the BANI, which is the main arbitration body here. It's the official arbitration body, but I think they have quite limited jurisdiction when it comes to intellectual property matters. And so, again, I would say that, you could choose arbitration in Singapore or in Hong Kong, which have very robust arbitration practices and histories. But, again, that would require your dispute to be heard there, and you would have to hire Singaporean counsel and all the other costs that would go along. Moving finally to domain names and the social media platforms. .id is the current level top domain from, I believe, 2017. So it's been around for about 5 years now. The older one is .co.id, less desirable these days. Pandi is the official Indonesian domain name registry, and that's where you go to obtain your .id domain. There are a lot of cases where people have gotten popular or famous domains first. Netflix, BMW, Nestle, Morgan Stanley, all of those were bought or obtained by you would say a non-authorized party. And in each of those cases, the true owner came along and filed a case before the PPND, which is the dispute resolution body within Pandi, and they were able to obtain their domain back. They were able to recapture it, and it's not that expensive. These have been a lot of really good, well thought out decisions. So I do think it's a reasonable option if you find yourself in the situation where your .id name has been taken. But you'll have to prove that you're the owner. You have to prove it through registrations of your IP right. Moving finally to social media. Indonesia's social media crazy. It's very young, very active, very digital. everyone has more than 2 phones. Everyone is on Instagram, TikTok, Facebook, Twitter, YouTube, all at the same time every day. So it's a really, really important part of doing business here is having a reach on social media. And of course, that means obtaining the relevant handles and, accounts as soon as possible before someone does it as well. Engaging with people in Bahasa Indonesia is always a plus, but it can be done in English as well. But the most important thing is to obtain that proprietary handle or domain name first before you start marketing, before you start making plans in Indonesia, so you don't have a situation where you're ready to launch and you realize that your handle has been taken. And it's the same thing with trademarks as well. And it applies to a lot of the IP rights just based on Indonesia as a jurisdiction. Really, really recommended to plan ahead and to line up your IP rights and domain names and social media handles as soon as possible. That's it from me. So, I'll stick around for the Q&A a little bit later on, but thanks for your attention.
Thank you very much, Andrew, for this very comprehensive presentation. It was a very good overview about the IP landscape of Indonesia and to know what's new and how COVID impacted it. So let's come back to you a little bit later for the Q&A. And now I would like to ask Eddy to start with his presentation on the role of customs. So we will be sharing the screen and you can control it.
Okay.
So. Okay, perfect. I see the slide change.
I have the control. Thank you. Thank you, Andrew, for your presentation. I also learned a few things, or a lot of things, about how it works before you arrive in customs. I'm going to try to give you a little bit of view about how is customs dealing with this IPR. But let's say firstly, I will give you a little introduction about the Belgium customs attaches and internationally seen customs. Are customs still existing? What are they doing to come down to the protection of the IP? So if firstly I take myself, I am the Customs Counsellor for Belgium in the Belgian embassy in Jakarta, and I'm working for Indonesia, but also for Vietnam, Singapore, Thailand, and Malaysia. So I have 5 countries to cover in all kind of tasks. On the other places in the world, we still have 3 other ones. We have somebody in Brazil, somebody in India, and another one in China. And if I go to myself, I am an experienced customs officer. So I'm a really long time working in customs. Firstly, I have been working for 37 years in Brussels Airport as responsible for the customs of the airport. In 2013, I moved to the Belgian embassy in Beijing, China, as customs attaché. And in 2018, I came to Jakarta, firstly only for Indonesia, but then since last year and beginning of this year, also for Vietnam, Singapore, Thailand, and Malaysia. What is a little bit the task of the Belgian customs attaches? In first option, of course, building a big network, representing Belgium customs to the diplomatic services, administrations, and certainly to our colleagues, the customs authorities of the different countries, so that it's easy to ask them something, to find solutions for everything, to cooperate, and much more. The second task, then we speak about facilitating and securing the safety of the supply chain. And then it's a little bit projects between customs, all kind of MOUs, letter of intents, exchanging of best practices, capacity building, everything in relation to, first, how do we check the goods? And secondly, how do we make it easier for the goods to pass the frontier without a check? So it's a little bit, yeah, a balance that we have to find between the two things. The third thing is then related to enforcement, the fight against economic and commercial fraud, cooperation with customs authorities of the countries, and then you have the whole chain of possibilities with, of course, also the IPR, the fake goods. Next to the site is the drugs, the waste, cigarettes, and much more. And one of the biggest tasks for me is then the economic support, and that means that I will do everything in relation to customs procedures, taxes, economic procedures for Belgium companies who wants to import in one of my countries, but also the opposite way, when Indonesian, Vietnamese, and whatever companies want to export to Belgium, to Europe, I will also help them, advise them, give them information, support them if there is a problem with a shipment, and so on. And also for private persons, that's mostly in relation to household goods who are transferred from one country to another. And then we have the customs, Belgian customs in this case, but I put Belgian between brackets because customs in the whole world, it's a little bit the same tasks we are doing. Firstly, we try to work for the finances of our country. Means import duties, excises, VAT. We do it in Belgium for Belgium. Indonesian customs is doing that in Indonesia for the Indonesian government. So each country has a little bit the same task. In my eyes, still the oldest profession of the world, customs, who are asking money, are asking import duties to enter a certain area. But nowadays, on the opposite, we also have the task to facilitate, to make it easier to pass the frontier without control. And one of the biggest examples for that is the AEO, the Authorized Economic Operator. So where a company is recognized as a partner of customs and a partner who is trusted and who can easily pass the frontier. And then the last two is protecting and safeguarding. And for that, I have a little bit of examples, like if we go in the fake goods, the IPR, the counterfeit, this is the numbers for Belgium. There are fake cigarettes, DVDs, jewelry, clothing, everything you can imagine. It's made in the counterfeit industry. So a lot of those things are imported and confiscated in Belgium. Next to the IPR counterfeit, we have the drugs. For the moment, Antwerp and also our colleague port in the Netherlands, Rotterdam, we are for the moment, let's say the big entry ports of Europe for cocaine. In 2020, we had in Antwerp port 66 tons of cocaine and a lot of other drugs. 21 was still more and 22 will be again more. We then also have the CITES goods, protection of the animals and plants. So like in this case, eagle and little frogs who are smuggled. And then the environment with the waste and everything around it, we are acting. And again, this is something not only in relation to Belgian customs, but internationally for all customs services around the world. Okay, then I'm coming to the IP in Indonesian customs. And in Indonesian customs, they have, like also in a lot of other countries, a recordation system. What means that after doing everything what Andrew already told us, you can also do the next step and registrate your goods in customs. So in the customs law of 2006, it was already foreseen that there were two possibilities, that on request of the owner to the commercial court, that he could give a suspension order, and that also the customs officer could do that. But yeah, it took 11 years to go to the next step, because this first step in 2006, this was the Indonesian customs law, where there was foreseen that customs could do something about the IP. But it took 11 years to have the governmental regulation to say, okay, this is what we all gonna follow, and we gonna act in relation to the Indonesian customs law on this way: IPR recording, pre-suspension, suspension, settlement, and so on national level. But it was still not the end. In 2018, finally, there was the regulation of the Ministry of Finance, because as you know, customs is depending from the Ministry of Finance. So in 2018, there was the Ministry of Finance regulation number 40, and that was again giving the way to act with this recordation system called ex officio, to say how will we do it, who will do it, and so on. Based on this rule, the customs of Indonesia, they did public hearings, they organized trainings together with the private sector to really teach the officers what is the best way to find it, what is the best way to do it. Because for it's very important to do something about the fake goods. And finally, in 2019, there was another regulation from the Supreme Court for the temporary suspension order. Okay, this was the law, but what does this all mean more practically? If I can go to my next slide. So firstly, if I believe what the MIAP, the Indonesian Anti-Counterfeiting Society, says, that was that in 2020 there was about 10 million US dollar counterfeit goods, and that was an increase of almost 350% since 2015. So in 5 years, it is becoming a much bigger problem. If we go down to the recordation system, that means that there is a system, an integrated system, integration of Customs, Supreme Court, Directorate General of Intellectual Property and Commercial Court. They are all connected to this system called SEA IP, and that's the system to record your goods, in fact. So you can do an online registration. It's free of charge. You don't have to pay. You can do the registration, and then if there is something, you will be notified by customs if something is happening. You can give all details of the goods. You can give whatever is needed to identify the real or the fake goods, and it's all in this system. Yes. So you are using the application for customs recordation. There is a problem with that. You have to be a business entity in Indonesia. So if you only have a distributor, it's impossible. He cannot apply for recordation. You really need a business entity there. The examination and approval done by customs of the recordation, it's valid for 1 year. If you are asking an extension at least 30 days before the period ends, you can have another year. And of course, it's applicable on the Indonesian territory. Something you have to do, you have to appoint an expert, somebody who really knows your goods, who can identify counterfeit goods, and who is familiar with all your channels of distribution and shipments and so on. So really the expert who can say, this is fake goods, these are the original goods. If there are changes, of course, you have to notify the system, customs, that something changed on your trademark or copyright. And if you say, okay, I don't need it anymore before the end of the year, you can always say, okay, I'm going to revoke it, I'm going to stop it, and you can notify customs. Okay, if then your goods are in this recordation system, okay, the customs can start to work with it. If the goods, or if certain goods are arriving, customs can do, of course, a check of the goods. They can do it documentary, they can do it physically, they can do whatever they choose. And the information that they find in your recordation will be a very good help for them to see if there is a risk, if there is a problem, and if it is maybe fake or infringing goods. If they think it is something that is not the real thing, they will notify the IP right owner or holder to say, we have a shipment and we think, or maybe it can be that it is infringing your IP rights. Very important then, as IP holder, you have 2 days to decide what you will do. You can say, okay, I don't care. They can do the importation, or I don't think, or I know it's real, or whatever. But you can also decide to submit a request for a temporary suspension order, and that's going to the relevant court. It's the court who will decide about the goods. As am I too far? Yes. So then the temporary suspension, if you decide to do it or to ask the court to do it, you have a few things you have to do. Firstly, you have to give to customs a guarantee of 100 million rupiah, means around 7,000 US dollars. You have to ask the temporary suspension request to the court, and you have to send the receipt to customs within 4 days after, the receipt is sent to customs within 4 days after confirmation of the request. On the other hand, customs, they have, after receiving the order for temporary suspension, they only have 1 day to tell to you, to the importer, to the exporter, to the IP right owner, and also to the Directorate General of Intellectual Property that for this goods, there is a temporary suspension. And that is, they will keep your goods for 10 working days. In that 10 working days that they keep your goods, you can ask the court to extend for another 10 days because you are still working on it. You still try to find out, is it guinea or is it fake goods? You can request the customs, but that's in the first period of 2 working days, to physically inspect the goods. Can you go again? Can you see? Can you check? Whatever. And you can also, or the temporary suspension period is ending after the 10 days normally, or if there is an order from the commercial court to stop the suspension, or on the other hand, you start with civil or criminal legal action to confiscate the goods and so on and so on. The responsibility for all these things, the storage, the handling, the labor and everything, it is possible that they will use your guarantee to pay this. But if, if it are really IP goods, normally they will not use the guarantee and they will refund it. But of course, if it is not the fake goods, you risk to pay a lot of money for this suspension system. And then my last day, maybe that's the reason of that thing. The last thing that I received or from customs is that in June 2022, so now for the moment, there are 24 or 25 IPR registered in the customs system. So that means they can act immediately without telling you when there is a shipment arriving based on the recordation system. They can act, but you also have, of course, the possibility that you didn't do the recordation, but that on one way or another. For me, it's totally unclear on what way you can know this, but let's say if you know that there is a shipment in customs and you think this is not my real goods, these are fake goods, you can do exactly the same, but then it's you who have to start. You have to report to the commercial court and you have to ask an order for temporary suspension. And for the rest, then the procedure is the same as the recordation procedure. So it's a little bit the difference between the two. If your goods are registered in the customs system and they see something wrong, they will start with the procedure. If your goods are not in their system, you have to know there is something wrong with this shipment and you have to start the procedure. So that's for me what is in relation to customs. And I give you my contact details that for everything you still want to know about customs, you still can contact me. Thank you.
Thank you very much, Eddy. Another very comprehensive presentation. And it's nice to link the customs topic with the previous presentation. So I don't want to take any further time from the audience. So just one reminder for everyone, you can still send any questions you have. So we can address it in a minute. In the meantime, our project published 3 publications, which we thought that could be very interesting for today's webinar attendees. So the first is, actually Andrew talked about it, is the Patent Cooperation Treaty, PCT. So you can learn a little bit more how you can have a patent in multiple countries, and also what are the pros and cons. The second one is similar to that one, but related to the Madrid system. So to register your trademark internationally in many countries, if you wish. And the third one is our IP fact sheet on Indonesia. So this is, you can download from our website easily. And then to wrap up the game, we as I mentioned at the beginning, we just wanted to quickly, very, very quickly check if you change your mind regarding the first 2 questions that I asked you when you joined the webinar. If you remember, I don't want to repeat the entire question. The first one is related to bad faith registration. So is there any risk if you don't register your trademark at an early stage? And the second question was related to invention patent grants an exclusive monopoly during a fixed period of time. So I want to give you 5 seconds because you listen to the presentation. So you just need to read the question and answer true or false. And then we move to the Q&A. Okay, let's share the answer. Yes, so both, actually the right answer is false for both questions. So for the first one is false 80%, and the second one 40%. So some of you should still review one more time the presentation, but I know it's a little bit long, the question, so probably we have to improve the format we ask, because it's a bit long. Anyway, thank you very much. And now the first question I would like to ask is actually to Andrew. What is the risk of having a trademark registration cancelled for non-use? One of our participants explained that, I don't know if you read it, Andrew, the question already. So yeah, then probably just go ahead.
So if you remember earlier, I mentioned that if the trademark is not used for at least 3 years from the date of its registration, or at least 3 consecutive years, it has a risk of potentially being canceled based on non-use. And so the question is asking about, what's the risk of that happening? It sounds like they've had experiences doing searches and finding some prior marks that might block registration of their marks, and they want to know if they can cancel it. And so it's important to point out, cancellation actions in Indonesia are before the commercial court. They are not administrative proceedings at the IP office like in some other jurisdictions. So it's proper civil litigation. So that means it's expensive. It also means that you need to submit sufficient evidence to carry your burden of proof. In a non-use cancellation proceeding, that means you need to have conducted a market survey. And so traditionally a market survey would go to, I think generally you could say we do 5 cities in Indonesia, 5 different cities, 20 locations in each city. So for 100 locations, we have a detailed report with photos and attestations and all different types of stuff. saying that, you know, we went to all these stores, all these cities, and we didn't find any evidence that this mark is being used. And so therefore the owner of this mark is not complying with their obligations under the Indonesian trademark law, and the court should cancel this mark. But, you know, you have to be pretty motivated to do that. You know, it's not, it's a 6-month process at the court. You have to hire people to do the market survey. You have to hire attorneys to litigate your case. So it can be expensive, absolutely. And it can take a little bit of time, and you might not get the result that you want because, you know, again, litigation can be unpredictable in Indonesia. So, you know, I think it's important to also consider other alternatives. One of those would be approaching the owner of the prior mark and seeing if you can purchase it. I think that's a much more direct and potentially efficient way. And, you know, maybe they want some money. Maybe they want a lot of money, but it might be less money than it costs to litigate. And it means that you obtain the rights to that mark as opposed to a cancellation action where you're merely canceling something and not obtaining anything for yourself. So, you know, I know that there are some people out there that have problems or maybe even company policies about rewarding bad faith behavior, not wanting to pay trademark squatters. Totally get it. That is an individual decision, business decision, but it can be quicker, it can be more efficient, and it can resolve your issue and allow you to start moving forward with your distribution with all of your plans in Indonesia much more quickly than going to court for 6 months. So, you know, that applies to bad faith, that applies to non-use as well. It is a real civil lawsuit, and that obviously requires time and money.
Yes, thanks for the clarification, Andrew. But one question for Eddy would be that when it comes to customs, do you think that they pay more attention to some specific products such as cosmetics or pharmaceutical or even, I don't know, wine spirit? If you have any experience on that, especially in Southeast Asia, that could be very useful to share.
Oh, let's say, wait, first, I want to do something next to your question. I just want to say hello to my colleague of the Netherlands who is in the public, Gusta Visser, who is doing exactly the same as I do for the Netherlands. So she's based in Singapore. So hello, Gusta. I hope you are good. Okay, sorry. I just want, yeah, for if they pay more attention. I think I saw that for Indonesia, there are 5 industries who are very high in fake goods and counterfeit, and that's fashion, culinary, pharmacy, cosmetics, and software. So I suppose my colleagues of the Indonesian customs, they also know this, and they put probably more attention to that than to other things. But for the rest, I don't have access to their system, so I don't know if they have other priorities. But like all customs around the world, I suppose, I don't suppose, I know, they are working with what we call risk analysis. So it's based on their risk analysis that they will check certain products, maybe certain countries, certain brands, whatever. It's really gathering information from everywhere and building that in an automated system to select certain goods. So in that category or as answer, I should also give a little advice to companies who want to have more attention from customs, that you give them all the information you can give. You can even, if you have the possibility, you can provide or ask them if you can give them a training to give the differences of your products. You can send them documents, whatever they can use to see the difference between the real and the fake goods. And I think the more knowledge they have, the more they know about certain products, the more attention they will pay to that products. So I think that's a little bit what you can do. And for the rest, it's really based on the risk analysis, and that can be different each week, each month, or each year.
Okay, thank you very much for the answer. And with that, I would like to close today's webinar because we don't have more time. So a very big thank you to our speakers. It was really great to have you on board. It was a good update. We had a good turnout in terms of participation. We recognize some of the attendees, so that's also very nice. So we hope that we can do another session on Indonesia sometime soon. And yes, also thank you for the participants who joined today. And as I said, we will be sharing the recording in a few days. So if you missed any information, you can cross-check it. Thank you very much, and have a good day to everyone.
Thank you. And thank you to all participants.
Thank you.